Bismillahirrahmanirrahim. Assalamualaikum. The name is RUSLI. My group and I will be discussing of the American Cyanamide case that has been acting as the guidelines in granting interlocutory injunction. In concept, an injunction is an act ordered by the court to do or prevent of an action by another party. An injunction acts as a relief of the party that has been inconvenienced by the other party. An English case has been decided by the House of Lords to be the guidelines of the court in granting injunction, the case of which is American Cyanamide Company against Eaton Company. Both companies are American companies operating in England. The applicant, American Cyanamide, had asked for injunction as the respondent, Eaton Company, was claimed to have copied applicant's product and would otherwise threaten appellant's control of the market. The court, in deciding of granting the injunction to the appellant, had gathered the prima facie of the case by both parties and had come to the conclusion to grant the injunction of the American Cyanamide, the decision of which was repealed and appealed again and to be given to the American Cyanamide. It is quite of a confusion. The prima facie of the case are important in deciding of which side of the party deserved the most in granting of the injunction. As per American Cyanamide case, the granting of interlocutory injunction is still a topic of confusion by the court.
In the case of PE Labelers and CFT Pacific Sdn Bhd and another against CFT SPA and another, one of the plaintiffs and the other plaintiff went into joint venture with the intention of finding new markets. The first plaintiff incorporated its branch in Vietnam, in which it held 60% of the shares, while a Vietnamese partner named Johnny Hoa held the remaining 40%. The second plaintiff, purportedly acting on behalf of the first plaintiff, appointed another Malaysian in his place to represent the first plaintiff as a shareholder in the Vietnam branch. Plaintiffs contended that injunctive reliefs were necessary to preserve the status quo and integrity of the instant civil suit between the parties. The court in this case applied the guidelines of the American Cyanamide case, namely, whether there is a serious question to be tried, the balance of convenience lies in favor of the applicant and that damages are not an adequate remedy. The court held that injunctions sought to restrain the second plaintiff as well as the first plaintiff, who were in Malaysia, from proceeding with a meeting to pass the proposed resolutions in Vietnam. Proposed resolutions would have given the second plaintiff almost complete control over the Vietnam branch as general director and would have made the other director there subservient to him. This court had jurisdiction to grant injunctions prayed for. The injunctions sought by the second plaintiff and the defendants in the civil suit against the first plaintiff were applied for to preserve the status quo pending the outcome of the trial of the action. The balance of convenience lay in the defendant's favor for the injunction to be granted. Damages were not an adequate remedy, as the harm that would befall the defendants was not of a kind that was able to be quantified.
Next, we also can see in this case of Perak Hydro Renewable Energy and Anor vs Wak Ngah Pili anak perempuan Bah Adim. In this case, the plaintiff filed an interlocutory injunction after claim that the defendant had trespassed their land and claimed that the project caused danger for Semai people living in surrounding areas, caused irreversible damages and pollution on the land. The interlocutory injunction is to prevent the defendant from continuing any works on their customary land as claimed by the plaintiff in this action. However, the defendant counterclaimed the injunction granted in this case as the injunction did not give justice for parties. The court in this case applied the principle of the American Cyanamide vs Ethicon Limited by considering in three elements. First, whether the plaintiff had a real prospect for injunction. Second, whether damages will be an adequate remedy. Third, the balance of convenience. For the first element, the court found that there is a serious issue to be tried as the plaintiff sought to prevent the defendant from continuing their works as the plaintiff claimed that the customary land belonged to them. It is sufficient for the court to determine if they are important enough to warrant a trial. For the second element, the court considered the final position of both parties. First, if the defendant afford to pay damages suffered by plaintiff if the plaintiff succeeded in the trial where the injunction is not granted. Second, if the plaintiff afford to pay if the defendant succeed and the injunction is granted. The defendant also claimed that the plaintiff never give any undertaking damages if the plaintiff failed in the trial as the plaintiff required to give an undertaking damages before the court grant an injunction. While for third element, the court granted the injunction by the reason the project causing danger to the local people and damaging their tanah adat and livelihood as the land is the source for their food, herbs and income. However, on the part of the defendant claimed that they will have a risk financial loss as they already invest large capital in this project. They also stated that the injunction will disrupt supplying electricity for the public. Plus, the project also will soon be completed. They also claim that the delay of 4 years by the plaintiff also ought to be considered as can cause great injustice and jeopardize for the defendant's project. The court held that in this case, the plaintiff not entitled for the injunction as the damages will be an adequate remedy in this case.
Another instance where the guidelines of American Cyanamide were applied in Malaysia is in the case of Poke Food, Sendian Berhad and another versus Fugitive Holding, Sendian Berhad and others. The plaintiff sought an interim ex parte injunction against the defendants for allegedly conspiring to undermine their business called the Fishbowl, which serves Hawaiian-style poke bowls as their specialty, by opening a similar restaurant named the Burn and Kubis and Kale. They further contended that the second and third defendants had breached their respective fiduciary duties by conniving against the plaintiff to open the burnt restaurant, poaching of the plaintiff's employees, and even embezzlement of the plaintiff's business funds. In this case, the presiding judge, Julie Lack JC, cited the case of American Cyanamide versus Ethical Limited and the principles. For the first element, the judge held that the plaintiffs had no basis to bar the defendants from selling the poke bowl since it was not proprietary to the plaintiffs alone. She also stated that the second and third defendants had no fiduciary duties on the plaintiffs after resigning. However, allegations of embezzlement and running a competing business should be decided in a trial, not in a hearing. Therefore, the judge held that there are serious issues to be tried. For the next element, the judge held that the plaintiffs are entitled to damages for profit loss from the second and third defendants' restaurant called Burn, but an injunction against the second defendant was not warranted. Furthermore, the owners of Kubis and Kale had no interaction with the plaintiffs. Therefore, she held that an injunction against them was held to be harsh and unfair without being decided in a trial. In other words, damages are adequate instead of an injunction. Lastly, on the balance of convenience, the court held in favour of the defendants due to the plaintiff's undue delay in taking legal action against Burns and allowing the ex parte injunction to lapse. Since the plaintiffs only applied for an interim injunction almost 13 months after the opening of Burn, this implied a lack of urgency displayed by the plaintiffs in obtaining an injunction and showed that they did not suffer a major hardship, citing the famous equity maxim of delay defeats equity.
The American Cyanamide case had certainly laid down its foundations in becoming guidelines for courts in granting interlocutory injunction. While its practice as a guideline, it had received a fair share of criticism from many of its unorthodox or even at times long-winding procedures. Even so, the case should never be overlooked as one of the leading cases that had tapped into the mire of the injunction itself.